Hello and welcome back to this channel. My name is Mandy Magnan. I'm a writer, actress, producer, and director in Toronto, a movie reviewer, pop culture, and your YouTube commentator for everything It Ends With Never. Well, my oh my, never a boring day. Wayfarer did not come to play, and when I show you what they filed, oh gosh, it's like they really sat back and waited, and then when it was time, they said, our turn, and they are coming with it. If you're ready, I'm ready. Grab your emotional support lip gloss. You are in frame with Mandy Magnan. Wayfarer just filed their memorandum of law in opposition for sanctions and spoliation, as well as a huge motion to I'm going to show you. I'm going to show you what's here. We're going to go over right away just the opposition, and hopefully we can get to some of the exhibits. However, I feel like this might be, again, a multi-part series just because of the time of the video. And then, of course, it's Friday, so I have a bunch of your comments queued up from the week, and I'm super excited to get into it. But let me just show you what happened in the courts. Okay, let me just show you. In yesterday's video, I kind of updated you on everything that was happening in the Jen Abel and Jones case, as well as everything in the Wayfarer case, because there is a lot of like little things filed. And we left off yesterday with the judge asking the Wayfarer people to, provide more of a fulsome response to the opposition for Ryan Reynolds, asking for sanctions. I feel like he's really opening the door and wanting to see all of the evidence that they have, because we know that they are probably going to be filing appeals, and the judge is like, let me just see what you have before I decide on this, okay? But then we wake up today to the Wayfarer people. It is wild. It starts with right away, they want to seal some of the exhibits. We'll get into that first. Then you have some declarations coming from Aline Garofalo. You have the response in opposition to the motion with all of these exhibits. There are 45 exhibits attached to the response. Then you have Jennifer Abel, who wants to seal her opposition to Jones' work, some of the sanction motions and exhibits in there. That is going to be sealed. And then you have Ellen Garofalo in opposition for the motion to sanctions from Jones' works and for spoliation. And then look, there's another 65 exhibits. I mean, it just continues and continues. Wowzers. What we're going to do right away is go in just to the first one, the response in opposition, and see what's there. And then in the next video, we'll do the Jones works and Abel one. And then I'll have to maybe do the exhibit separate. I don't know what's going to happen, but I'm going to get you all the information. Okay, so let's just go right away. I am very excited to dive in, as maybe you can tell, but it is a good day because now is the time. I'm really hoping that most of these things get tossed out when the judge does rule on the motion for summary judgment, as well as motion on the pleadings. But it looks like they're coming with their full arsenal. Let's read the first sealing, and then we'll get into the letter response in opposition for spoliation and sanctions from the Wayfarer people. I did only read the introduction, and it got me so fired up. I was like, I gotta go now. Let's do it. So let's just read through it, guys. Immediately, there is something for sealing because, of course, there's going to be information there and stuff from Blake Lively and her deposition and any communications from her that, she doesn't want nobody to see nothing. It says, on behalf of defendants Wayfarer Studios, Justin Baldoni, Jamie Heath, Steve Saritz, It Ends With Us Movie LLC, Melissa Nathan, The Agency Group PR LLC, and Jennifer Abel, collectively the Wayfarer parties. We write, pursuant to Rule 4B of Attachment A to your Honor's individual rules, to respectfully request that the court preliminarily seal sections of the opposition to Jones Works' motion for spoliation sanctions and exhibits 2, 5, 6, 7, 9 to 11, 13, 15, 20, 23 to 28, 30, 32 to 34, 39 to 43, 45, 47, 54, and 59 to the declaration of Aline S. Garofalo, filed contemporaneously within. Then it just says that exhibits 5, 6, 13, 23 to 26, and 40 are deposition testimony and documents produced by plaintiff Blake Lively and designated by her as confidential. Exhibits 45 and 54 are deposition testimony in a document produced by third-party Catherine Case and designated by her as confidential. Exhibits 15 and 20 are excerpts of deposition testimonies from third-party Andrea Giannotti, which are designated as confidential. Exhibit 39 is an excerpt of deposition testimony of third-party Colleen Hoover, which is she designated as confidential. And Colleen Hoover, you're so lucky this dropped today because it's given me a second before I come back to you after that little L interview. You're lucky. You're lucky you have a moment, okay? Exhibit 27, 28, 32, 41, and 43 are documents produced by third-party Sony Pictures Entertainment and designated confidential. Exhibits 30, 33 to 34, and 42 are documents produced by third-party WME and designated as confidential or confidential attorney eyes only. Exhibits 7 and 9 through 11 are documents produced by third-party Van Zandt and designated confidential. Exhibit 59 is an excerpt of the deposition of Jed Wallace and is designated confidential. The redacted portions of the opposition memorandum similarly refer to the testimony contained in the aforementioned documents that were designated as confidential or confidential attorney eyes only in accordance with Rule 4B of Attachment A. The Wayfarer parties respectfully request that the court not rule on this letter motion to seal for 1 week so that the parties can come and decide whether they, want to unseal or not. In addition, the Wayfarer parties respectfully request that the court permanently seal Exhibit 22 and 55 to the declaration of Aline S. Garofalo. Exhibits 22 contains high, intimate, and personal communications with third parties to this litigation and therefore is highly confidential pursuant to the protective order. Exhibit 55 is the engagement agreement between the Wayfarer parties and Liner, Freeman, Tailman, and Cooley LLP, produced by defendant Jennifer Abel. Its substantive contents are not relevant to the motion or to the underlying dispute in this action. The substance of Exhibit 55 contains confidential and sensitive information relating to the attorney-client relationship between Liner and his clients, including attorney rates and other terms of the Wayfarer parties' engagement, and therefore is confidential pursuant to the protective order. And the Wayfarer parties would like to keep that permanently confidential, which completely makes sense. Buckle up because here we go. Blake Lively is the plaintiff against all these people. Defendant's opposition to plaintiff Blake Lively's motion for spoliation sanctions. Plaintiff Blake Lively or plaintiff, sanction motion should be denied. Plain and simple, we're done. That's over. We don't got to read anymore. Lively seeks the most severe sanctions available under Rule 37E, including an adverse interference that in August 2024 crisis management strategy was not only planned but executed, and a preclusion order barring defendants from presenting any evidence refuting Lively's claims that they executed on the plan to manipulate the internet to defame Lively and derail her career, for which she is now seeking a mere $300 million in damages. just a little $300 million, no big deal. Lively's showing falls woefully short of the harsh standard for sanctions under Rule 37E2, or even the lesser sanctions available under Rule 37E1. Boiled down to its essence, the motion asserts that some defendants may have used Signal to discuss topics related to this litigation prior to the December 2024 filing of Lively's complaint without disabling the auto-delete feature. Lively assumes and asks the court to assume that all 8 defendants deleted messages that might have further shown that defendants executed on a crisis management strategy that turned the internet against Lively in 2024 at the time the film It Ends With Us was released. The mere assumption that some or all defendants may have deleted relevant evidence, even intentionally, is not enough to justify sanctions that would devastate the defense of 8 defendants. The motion's first flaw is that Lively seeks blanket sanctions against all defendants without distinction. Rule 37E sanctions are personal and cannot be awarded against a group of 8 without proof that each independently spoliated evidence. Lively fails to show that any message evidencing the implementation of a smear campaign was deleted by a particular defendant, or even that all defendants used Signal to communicate about Lively prior to the filing of her complaint. Rather, Lively, indiscriminately seeks sanctions against all 8 defendants. Plaintiff admits that it is unclear whether all defendants used Signal prior to December 2024. Oh my gosh. The allegation that all defendants executed a crisis management strategy to manipulate the internet, Lively refers to this as the digital campaign, is based solely on the supposition that negative publicity about Lively went viral in August of 2024, and thus defendants must have been the cause. In fact, Lively fails to identify specific communications that might demonstrate the implementation of the digital campaign. Yeah, she still doesn't have nothing. She fails to identify any specific communications that demonstrate that they actually implemented anything. Interesting. She only speculates that such evidence may or must have existed and been automatically deleted. What's really crazy about that is her lawyers all spring, all summer, were coming out saying they have a ton of evidence. They already have more than enough. Remember all of that gaslighting they tried to do? I won't forget. It's in here still. Lively stubbornly refuses to acknowledge or take any responsibility for her own conduct, which was the impetus for the public backlash that spiraled out of control when the film was released in August 2024. Lively also fails to make the critical threshold showing the application of Rule 37E, namely that any defendant anticipated litigation over a smear campaign, the purported subject of the allegedly deleted communications, and thus a duty to preserve any evidence prior to the filing of Lively's December 20th complaint. Lively's claims fall into 2 categories. 1. Claims related to alleged sexual harassment and gender discrimination by certain Wayfarer defendants occurring between May 15th and June 14th of 2023. And 2. Claims relating to an alleged digital or smear campaign that allegedly began in August of 2024. The Signal messages that are the subject of plaintiff's motion relate to the digital or smear campaign allegedly conceived in August 2024, not Lively's sexual harassment claims, which arose between May 15th and June 14th of 2023. Plaintiff does not even attempt to show that any party contemplated litigation over a public relations strategy or digital campaign when unspecified Signal messages allegedly were deleted by any defendant. Plaintiff merely points to a November 9th, 2023 demand letter relating to the objection she rose in 2023 and defendant's discovery response, which confirmed that in November of 2023, they anticipated litigation in connection with the shooting of the film in May and June 2023. Lively fails to demonstrate that defendants reasonably foresaw litigation in which the August to December 2024 Signal chats must be relevant and thus fails to establish a duty to preserve those messages. Lively next fails to show prejudice caused by the acts of any defendant, a predicate for Rule 37E sanctions. In fact, plaintiff fails to show prejudice at all. Lively contends that severe prejudice is obvious because deleted Signal messages may have further shown defendant's execution of the digital campaign, thereby impairing Ms. Lively's ability to fully prosecute her claims and rebut the defense that the Wallace defendants decided after being retained that no proactive digital campaign work was required given organic online sentiment. Yet, on the very first page of her motion, Blake Lively admits that she was not prejudiced by the deletion of Signal threads by noting that despite defendants' alleged efforts to cover their tracks, there is substantial evidence that the retaliatory campaign was in fact implemented as planned. I knew those words were going to come back to haunt her. She wrote it in her own CRD. That there's substantial evidence. Okay, well, if there's already substantial evidence on the time of filing, why do you need these couple of Signal messages then, huh? Lively also produced multiple excerpt reports which rely on the evidence she provided to opine, albeit erroneously, on the execution of the digital campaign, since she admittedly has substantial evidence that the digital campaign was implemented. Lively cannot establish prejudice from the purported denial of further evidence, which may be subject to exclusion as cumulative. Absent a showing of prejudice, plaintiff is not entitled to sanctions under Rule 37E. Lively thus fails to establish the right to sanction under 37E1, which upon a showing of prejudice are limited to those sufficient to cure the prejudice she has not shown. But Lively does not seek sanctions under subsection E1. She seeks the more severe sanctions of an adverse inference and preclusion available only under Rule 37E2. Failing to meet her burden under Rule 37E1, Lively is not entitled to sanctions under 37E2. Even assuming she met her burden under 37E1, Lively fails to establish that any defendant acted with the intent to deprive her of specific evidence for use in this litigation, a predicate for the onerous sanctions available under subsection E2. As elaborated below, conjecture and speculation are insufficient to justify sanctions. Oh, lordy, lordy, lordy. They are just going to eat her up. I have a feeling that this is going to get spicy. As elaborated below, conjecture and speculation are insufficient to justify sanctions under Rule 37E, much less the severe sanctions of an adverse inference and presumption that damaging evidence existed and was deleted. In fact, this is only one of multiple sanction motions in which Lively, implicitly conceding that the evidence adduced in discovery will not support her claims, seeks to exclude evidence crucial to the defense, crippling the defense of 8 defendants to avoid having to prove claims with admissible evidence, is not a proper purpose for Rule 37E. Now, if we just go over it, she's asking specifically that the signal messages, because they can't provide them because they were on auto delete and maybe some of the people weren't even using Signal at that time, she's asking that the court allow her to say that those Signal messages that were deleted, if they even existed, that those Signal messages prove the smear campaign and that the Wayfarer people can't oppose it. She's also asked the court for Jamie Heath to not be able to testify about anything about the birthing video. That was already denied. She's really out here filing these sanctions, really asking the judge to preclude the Wayfarer from being able to even defend themselves at this point. It's kind of nuts, and it's super biased and one-sided, and that's what she wants. I think she wants every chance that she can get to stack the hand, to stack her hand because of lack of evidence. I mean, we all know it's gotten too far and that she has nothing, and it's just, it's going to be real embarrassing for her and Ryan Reynolds. Even though I feel like they are backed from some pretty mighty powerhouses like WME, like Sony, who really need them to win. We'll see, because the law's still the law, and you got to have evidence. And if it comes down to a jury, ain't no way she's getting $300 million. No. Factual background. Plaintiff asserts claims for sexual harassment and retaliation under FEHA and Title VII, as well as defamation and other reputational harm against defendants Justin Baldoni, Jamie Heath, Steve Saretz, Wayfarer Studios, It Ends With Us, collectively the Wayfarer defendants. Oh, why is my nose so itchy today? It's driving me crazy. Plaintiff also complains that Wayfarer's public relations crisis management team, Jen Abel, Melissa Nathan, and the agency group PR LLC were involved in an alleged digital campaign that manipulated negative content against Lively on the internet. The relevant facts are summarized below. Oh, can't wait. It does say in the footnote here, plaintiff devotes much time to arguing that defendants were too slow in producing documents or otherwise engaged in efforts to obstruct discovery. Defendants deny these accusations. Most importantly, perceived shortcomings in defendants' discovery efforts are not relevant to a Rule 37E analysis, as the court cannot impose sanctions for spoliation of ESI pursuant to its inherent powers. Do you hear that, Judge Lyman? Do you hear them? They were pretty clear. The film It Ends With Us and Lively's complaints about misconduct on the set. Let's get into it. The film began shooting in New Jersey and New York on May 15th, 2023, Phase 1. Phase 1 ended on June 14th, 2023, due to the Writers Guild and SAG strikes. During phase 1, Lively complained about purported mistreatment on the set by Baldoni and Heath, including alleged conduct that made her uncomfortable. See generally. Her complaints range from wardrobe and scheduling issues to Baldoni's statements that she looked hot or sexy in a costume designed for an intimate scene between Baldoni and Lively's characters, and Heath showing her a video of his wife after the birth of his daughter in connection with the filming of a birthing scene. Lively did not file a formal complaint but voiced concerns to Baldoni, Heath, and others, including the film's distributor, Sony, no later than June 1st, 2023. The protections and resolution of Lively's complaints. During the strike-related pause in filming on November 9th, 2023, the Wayfarer defendants received a letter from Lively's lawyers, Lindsay Strasberg, demanding the Wayfarer agree to a 17-point list of protections as a condition for Lively's return to complete the film. The letter stated that if the production is unwilling to accept or uphold these protections, our client is prepared to pursue her full legal rights and remedies. Under extreme financial pressure to complete the film and pressure from Sony, the film's co-investor, Wayfarer agreed to the protections. The Wayfarer defendants understood that their agreement to the protections resolved the issues that had arisen during phase 1 and eliminated the threat of potential litigation. Obviously, yeah, it's as if you are unwilling to accept or uphold these protections, which they did do, and even in Blake Lively's own CRD, she said everything was fine after. Filming resumed on January 5th, 2024, following an extremely tense all-hands meeting on January 4th, in which Lively's husband, Ryan Reynolds, spent hours berating the Wayfarer defendants for their conduct in Phase 1. After returning to the set, Lively did not assert any further complaints. Filming, which began on January 5th, wrapped on February 9th, 2024. There is no evidence or even allegation that the Wayfarer parties failed to uphold the protections during the second phase of filming. In fact, on January 14th, 2024, and then it's redacted. And I bet this is going to have something to do with Lively reaching out to someone, Lively saying to someone, something like that, right? The PR defendants were not parties to the protections, did not attend the January 4th all-hands meeting. Attendees at the meeting included Mr. Baldoni, Mr. Heath, Miss Giannotti, Alex Sachs, Todd Black, Miss Lively, Miss Lively's husband, Ryan Reynolds, and did not have any contact with Lively about her complaints of misconduct in Phase 1. Lively hijacks control of the film from the Wayfarer defendants. Call it out, baby. Yes, she did. She hijacked that man's movie, okay? During the second phase of production, Lively moved to seize control of the production. Among other things, she wrestled control over editing, post-production, and marketing from Baldoni and Wayfarer. Ultimately, Lively gained control over the entire post-production process. Then it's redacted. Lively also demanded that Baldoni's film by credit be removed. Then it's redacted. And that comes from Baldoni as well as Greenberg's deposition. Lively accomplished her takeover through threats that if her demands were not met, she would not participate in marketing the film, even though she was contractually obligated to do so. You're done. It's a wrap, Blake. It is in the contract that she was to market the film, so she was literally threatening them to breach her own contract in order to get her way. Not content with usurping Baldoni's role as director and excluding him from the marketing of the film he developed, financed, directed, and starred in, Lively then sidelined, indeed banished Baldoni from the premiere, refusing to be photographed with him, and demanding that he and his guests be hidden from sight and shunning Baldoni and his guests into another screening room. Baldoni was also barred from appearing with Lively in publicity photos or promotional appearances. Lively very publicly unfollowed Baldoni on social media. The public relations response to Lively's attacks and the surging chatter over Discord on the film's set. By the time the film's August 6th, 2024 premiere, rumors of discord on the film set were already swirling on social media and in the press. These rumors were fueled by blank, and I bet that has to do with Leslie Sloan and Blake Lively. Lively's blank. Lively's unfollowing of Baldoni on social media and Lively's insistence that Baldoni be stripped of the credit filmed by Justin Baldoni on the movie he developed, sold, directed, and starred in. Lively was also redacted. And I wonder if that has to do with the PR that they did, because then they get right into how she was hawking alcohol and hair care products. So this decision was particularly tone deaf given the role of alcohol abuse and domestic violence cases. Nevertheless, Lively used alcoholic drinks using her Betty Booth alcohol product such as Ryle You Wait and It Ends with Buzz at promotional events. The public backlash was immediate and unforgiving. And then they have some articles that came out about that. And that was way before they hired Melissa Nathan and Jed Wallace, baby. Given the circumstances and Lively's affirmatively hostile conduct, the Wayfarer parties were understandably concerned about a potential onslaught of negative publicity from Lively. On July 25th, 2024, the Wayfarer parties contacted crisis communication specialist Melissa Nathan and her company TAG to defuse and defend against Lively's anticipated assault and protect the film and Baldoni's professional reputation as a producer and director. The Wayfarer defendants also retained Jed Wallace to provide digital monitoring services. Nathan, who was first engaged as a crisis manager PR on August 2nd, 9 months after the Strasbourg's letter, and over a year after the alleged act Lively now claims as harassment, had no involvement with the film or the Wayfarer defendants during filming, did not receive a copy of the Strasbourg letter, and had no contemporaneous knowledge of Lively's litigation threats. However, Heath provided Abel with a copy of the Strasbourg letter and the 17-point list of protections on November 10, 2023. On August 2, 2024, the Crisis Management Public Relations team circulated a scenario planning document with a proposed strategy to counter against negative press and Lively's efforts to disparage Baldoni and Heath as the film's director and producer, respectfully tamp down the growing chatter on the internet's rumor mill and handle the responses should Lively and her team make her grievances public. Lively defines this defensive measure as the launch of a retaliatory smear campaign and contends that in the weeks and months that followed, the Wayfarer parties engaged in a sophisticated, coordinated, and well-financed retaliation plan. In fact, the Wayfarer defendants did nothing other than exercise their right to defend against Lively's attacks and the tidal wave of negative publicity triggered by Lively's conduct. Lively implicitly concedes that the goal of the Wayfarer defendants' public relation efforts was not retaliation for some protected activity, but to defend Baldoni and his reputation. The strategy described in the scenario planning document was never implemented. Anti-Lively, pro-Baldoni sentiment went viral organically. The negative publicity spiked on the eve of the August 6th premiere and August 9th release date. Plaintiff's own timeline indicates that defendants could not have been the masterminds behind the spike in negative publicity. Plaintiff points to spikes in negative internet traffic on August 8th and 14th. By no later than August 12th, 2024, defendants took to the offensive. Using their words, it was time to lawyer up and get ready to fight and go to war. Wallace was recommended by defendants on August 8th and engaged on August 9th. The first spike in negative digital coverage began on August 8th before Wallace, the alleged digital wizard, was retained, and only 1 day after he was referred by Nathan. Even looking at the August 14th spike, plaintiff does not offer any explanation about how the PR defendants and Wallace were able to turn the entire internet against Lively in less than 2 days. These facts undermine Lively's presumption that defendants manipulated the spike in the already burgeoning negative sentiment targeted at Lively. These facts undermine Lively's presumption that defendants manipulated the spike in the already burgeoning negative sentiment targeted at Lively. The use of Signal by some defendants. After the crisis management team was brought on board in August 2024 and prior to plaintiff's filing of her claim in December 20th, 2024, certain defendants used Signal chats to communicate. Signal is a commonly used app which provides enhanced security features. The security protection Signal provides made Signal the preferred and primary means of communication between Nathan, the crisis manager, and Jed Wallace, who operated in a highly charged media environment. Other defendants use Signal on limited occasions. Jamie Heath communicated at least twice on Signal during this period. Saritz, Baldoni, and Abel did not use Signal at all during the pre-litigation period to communicate about Lively. And that's coming from their own deposition. So they didn't even use Signal, girl. What is you doing? However, to the extent Signal was used, the participants had Signal set on its auto-delete feature. Defendants therefore have no Signal communications from pre-litigation period. However, defendants also use traditional platforms such as text messaging to communicate about Lively. These messages have been produced, and some of these messages may be included in the substantial evidence Lively claims exists. Plaintiff filed her CRD complaint on December 20th. And the same day sent a cease and desist letter advising the parties of a litigation hold. Mr. Freeman, although he had been introduced to defendants in August of 2024, was not retained until December 24th, 2024. The engagement letter cautioned defendants to preserve documents. Shortly thereafter, defendants switched off the auto-delete feature. Non-privileged Signal communications after December 20th have been produced. Plaintiff fails to meet her burden to show that she is entitled to sanctions under Rule 37E1. Spoliation is the destruction of significant alteration of evidence or the failure to preserve property for another's use as evidence in pending or reasonably foreseeable litigation. Federal Rules of Civil Procedure 37E govern spoliation of electronically stored information, ESI. Rule 37E sanctions are entrusted to the court's discretion. A party seeking sanctions for spoliation has the burden to establish 1. That the party having control over the evidence had an obligation to preserve it at the time it was destroyed, and 2. That the evidence was destroyed with a culpable state of mind, and 3. The destroyed evidence was relevant to the party's claim or defense, such that a reasonable tier of fact could find that it would support that claim or defense. There are 2 levels of sanctions under Rule 37E. Sanctions under Rule 37E1 are available upon a showing of prejudice and are limited to measures no greater than necessary to cure the prejudice. Under Rule 37E1, a court may permit the prejudiced party to present evidence to the jury concerning the loss and likely relevance of information and instruct the jury that it may consider the evidence along with all other evidence in this case in making its decision. More severe sanctions, including an adverse inference, presumption, and terminating sanctions, are available only under Rule 37E2, which requires an additional showing that the spoliating party deleted or destroyed evidence with the intent to deprive the non-spoliating party of its use in the litigation. As noted, plaintiff is seeking draconian sanctions available only under Rule 37E2, including an adverse inference that defendants intentionally deleted and failed to preserve relevant evidence when they had an obligation to do so, and that the destroyed evidence would have further shown defendants' execution of the digital campaign, and an order precluding defendants from arguing that they did not execute their digital campaign and they openly planned to do so. Imposition of such sanctions would be tantamount to a dispositive ruling on plaintiff's retaliation and defamation claim. Plaintiff fails to establish sanctionable conduct by any particular defendant. As a preliminary matter, Rule 37E sanctions are personal, and the destruction of documents by one party cannot give rise to a spoliation sanction against another party. Favorably citing case law for the proposition that spoliation sanctions must be assessed independently with respect to each individual defendant, and holding that spoliation sanctions were unwarranted against those individual defendants where plaintiffs could not demonstrate they actually spoliated any evidence. Plaintiff does not identify which of the 8 defendants may have used Signal and deleted specific items of relevant evidence. Plaintiff merely asserts in the most conclusory fashion that there is no dispute that each of the defendants used Signal as an informal messaging platform to discuss issues related to this litigation, and that in August 2024, all defendants, including Nathan, decided to go to war. There may be no dispute that some defendants used Signal. There is certainly a dispute over whether all defendants used Signal and whether any defendant deleted messages evidencing the execution of a planned digital campaign. In fact, there is no evidence that most defendants used Signal prior to December 20th, 2024. much less used Signal to communicate about this litigation or deleted relevant evidence. Plaintiff concedes that the pre-litigation Signal threads relating to Lively were used primarily by Nathan and Wallace, and admits that it is unclear whether Mr. Baldoni and Mr. Saritz were separately using Signal prior to December 20th. Saritz, however, did not believe he used Signal to communicate about the film prior to December 20th. Baldoni also did not use Signal prior to December 20th to communicate about Lively, but only used it in connection with the men's support group unrelated to Lively or this action. Heath downloaded Signal in August 2024 and briefly connected with Wallace. There is no evidence that Heath's handful of messages evidence or even reference the implementation of a plan to manipulate the internet to ramp up negative publicity about Lively. Abel did not use Signal prior to Lively's filing of her complaint, except for communications relating to another very high-profile client unrelated to this action. In sum, plaintiff fails to show that a particular defendant used Signal during pre-litigation period, much less deleted evidence that defendant's public relations strategies outlined in the scenario planning document were put in motion. Yet the blanket sanctions sought by plaintiff would effectively strip all 8 defendants of any ability to defend against her retaliation and defamation claims. Plaintiff is not entitled to blanket sanctions against all 8 defendants without specifically identifying what evidence each defendant allegedly possessed and deleted. Plaintiff fails to show that defendants had a duty to preserve allegedly deleted evidence. To even establish Rule 37E even applies, a party seeking spoliation sanctions must show that the destroying party had an obligation to preserve the evidence at the time it was destroyed. The duty to preserve evidence most commonly arises when suit has already been filed, providing the party responsible for the destruction with express notice, but also on occasion in other circumstances, as for example when a party should have known that the evidence may be relevant to future litigation. Sanctions not warranted where defendants denied that they had engaged in misconduct, and thus they had no reason to expect litigation. Defendants would have reasonably anticipated that there would be sued prior to the date. A plaintiff's duty is more often triggered before litigation commences, in large part because plaintiffs control the timing of litigation. Unlike defendants, plaintiffs may be imputed notice on the duty to preserve potentially relevant evidence prior to the filing of the complaint. Plaintiffs are in control of when the litigation is to be commenced and must necessarily anticipate litigation before the complaint is filed. Plaintiff contends that Strasburg's November 9, 2023 demand letter placed the Wayfarer defendants on notice of potential litigation and that the evidence was relevant to litigation. Plaintiff also cites defendants' interrogatory responses, which acknowledge that the Wayfarer defendants recognized the possibility of litigation relating to the shooting of the film in or around mid-August 2024. Emphasis added. In other words, the only litigation that could have been anticipated in August 2024 involved Lively's objections in Phase 1. However, Lively's motion is based on the premise that allegedly deleted Signal threads may have been relevant to the execution of the digital campaign, not Lively's claims of harassment or discrimination during Phase 1 of shooting. Plaintiff provides no support for the allegations that any party contemplated litigation over a public relations strategy or digital campaign when Signal messages were deleted. And naturally, Lively does not explain how any defendant could not have reasonably foreseen litigation in November 2023 over a retaliatory smear campaign that did not happen until August of 2024. In fact, even the threat of litigation over Lively's harassment allegations dissipated when the Wayfarer defendants agreed to the protections. Lively and Strasburg's express condition for avoiding litigation. Finally, Lively identifies Nathan as the most frequent user of Signal. Nathan was retained in August of 2024 as a crisis manager to handle the growing public relations crisis spurred by Lively's efforts to seize control of the film and sideline Baldoni and Wayfarer. There is no evidence that prior to December 20th of 2024, Nathan had reason to anticipate litigation involving her crisis management activities on behalf of the Wayfarer parties. In fact, there is no evidence whatsoever that Nathan could have reasonably foreseen even litigation relating to Lively's earlier objections. Nathan was not involved with Wayfarer in 2023, and there is no evidence that she knew of Strasburg's November 9th, 2023 demand letter, or even the nature of Lively's complaints. Plaintiff cites not a whit of evidence that the war was in any way linked to Lively's discrimination claims. In other words, there is no evidence that Nathan and Tag could have reasonably foreseen litigation, giving rise to a duty to preserve evidence when their signal messages were deleted. Plaintiff fails to show that the allegedly destroyed documents existed. Rule 37E requires a showing that evidence existed and was destroyed. An assumption or speculation that allegedly deleted relevant evidence existed is not sufficient. Then they go into a few cases where that has been ruled before, and it's all about these cases were denying spoliation sanction based on pure speculation. They denied spoliation sanctions where plaintiff failed to show the documents even first existed. And because plaintiff's arguments that there has been any actual loss of evidence relevant to the claims or defenses in this case amounts to pure speculation, it is insufficient to sustain a motion for spoliation sanctions based on frickin' speculation. Plaintiff glosses over this technicality, asking the court to assume that defendants deleted signal chats evidencing that they executed the public relations crisis management strategy. Such assumptions based solely on speculation are insufficient to justify Rule 37E sanctions. Plaintiff disingenuously cites Barbara 2025, where this court granted Rule 37E1 sanctions. There, it was undisputed that plaintiff destroyed specific evidence showing when plaintiff discovered the alleged infringement at the heart of his claim. Although it was unclear precisely what documents were lost, it was not disputed that the deletions included documents recording his discovery of the alleged infringement, including his initial correspondence regarding the discovery, which established not only the time of his knowledge, but that he anticipated litigation at the time he deleted the documents. Plaintiff's destruction of the evidence prejudiced the defendant's ability to prove a statute of limitation defense. These facts are in sharp contrast to this case, where plaintiff fails to identify a single item of relevant evidence that was destroyed by any defendant. Plaintiff fails to show prejudice. A showing of prejudice is crucial to a spoliation analysis under Rule 37E. Plaintiff contends that deleted communications may have further shown defendant's execution of the digital campaign, and thus severe prejudice is obvious because relevant communications were deleted, impairing her ability to fully prosecute her claims, and rebut the defense that the strategy for a proactive digital campaign was abandoned because of organic flood of negative internet activity spawned by Lively's own conduct. Lively herself rebuffs the notion of prejudice on the very first page of her own motion, admitting that despite defendants' efforts to cover their tracks, there is substantial evidence that the allegedly retaliatory campaign was implemented as planned. Lively fails to explain why, if she already has substantial evidence, the lack of further evidence prejudices her ability to prove her claim. In fact, district courts routinely exclude relevant evidence that is needlessly cumulative. So they're saying, like, even if you did get those signal messages, you said that you had all of the evidence that you needed already. Where is the evidence? Rule 37E1 authorizes an award of attorney fees and costs to the moving party to the extent reasonably necessary to address any prejudice caused by the spoliation. The purpose of this remedy is to ameliorate the economic prejudice imposed and also serve as a deterrent to future spoliation. As shown above, plaintiff fails to show that defendants or any of them violated Rule 37E, much less that she was prejudiced by a deletion of relevant signal messages. Accordingly, plaintiff is not entitled to reasonable attorney fees to cure any imagined prejudice. And yeah, like, we're not gonna pay her because she's like imagining all of this stuff and just getting her lawyers to work and do a bunch of PR in the courts. Nope, it's all imagined. It's all BS. Plaintiff fails to show that any defendant had a culpable state of mind when signal messages automatically deleted. As noted, Baldoni and Seritz did not use Signal to to communicate about the film prior to the filing of her December 2024 complaint, and therefore could not have deliberately deleted Signal chats. Abel used Signal prior to December 20th, but not to communicate about Lively. Nathan and Wallace routinely use Signal for the security it provides to protect sensitive crisis management communications for their high-profile clients. The Tag and the Wallace defendants appear to have used ephemeral messaging as a part of their regular business practice. Plaintiff concedes that the Signal auto-delete feature was disabled after litigation commenced, and defendants have produced post-filing Signal messages. These facts weigh heavily against the notion that in using Signal and its auto-delete, defendants acted with culpable intent to delete relevant evidence. With respect to the Wayfarer defendants, the motion is silent on culpable intent, with Lively merely asking the court to extrapolate intent from the fact that the auto-delete feature was used. This is insufficient for Rule 37E sanctions. Plaintiff fails to meet her burden under Rule 37E2 for the severe sanctions she seeks. Rule 37E2 provides 4 more severe sanctions, including an adverse inference and preclusion. Plaintiff seeks an adverse inference and preclusion order establishing that allegedly lost ESI was unfavorable to plaintiff and barring defendants from presenting any evidence to support their defense that the strategies set forth in the scenario planning document were never executed. Such an order would conveniently relieve Lively of the burden of having to prove her claims with admissible evidence, something discovery has shown she cannot do. I mean, there it is. That's fire right there. That's exactly what she wants. She wants to silence them yet again so that they have to take whatever she's saying as true, right? Trust Blake Lively, her word against all of these other people, because she doesn't actually have any evidence, and she never did from the very beginning. This whole thing has been a farce. The more severe sanctions available only under Rule 37E2 requires a showing that the spoliating party intended to deprive the moving party of information for use in this litigation. The intent standard for sanctions under Rule 37E2 is particularly harsh and stringent and specific. The moving party must show not merely the intent to perform an act that destroys ESI, but rather the intent to actually deprive another party of evidence. A showing of prejudice from the destruction of highly relevant or even dispositive evidence may be insufficient for Rule 37E2 sanctions, absent a show that the evidence was destroyed with the intent to deprive the moving party of its use in the litigation. It is not merely the intent to perform an act that destroys ESI, but rather the intent to actually deprive another party of evidence. The Second Circuit applies 4 factors to determine whether a party acted with the intent to deprive. 1. Evidence once existed that could fairly be supposed to have been material to the proof or defense of a claim at issue in this case. 2. The spoliating party engaged in an affirmative act causing the evidence to be lost. 3. The spoliating party did so while it knew or should have known of its duty to preserve the evidence. And 4. The affirmative act causing the loss cannot be credibly explained as not involving bad faith by the reason proffered by the spoliator. Blake Lively, the plaintiff, fails to meet any prong of the intent to deprive test. Not even one of them. First, as shown in Section 3C above, Lively fails to show that relevant evidence existed. At issue are Signal chats between the Public Relations Crisis Management Team and/or Wayfarer defendants in the pre-litigation period, August 2024 to December 20th, 2024, when Lively filed her complaint. At best, plaintiff proffers that at least some of the defendants used Signal to communicate about this case. Plaintiff only speculates that the deleted chats may have included evidence that defendants executed on a plan to manipulate internet traffic. Second, plaintiff does not show that defendants engaged in an affirmative act causing the evidence to be lost. As noted, Nathan, the primary user of Signal chats, routinely used the messaging system, and there is no evidence that she deliberately set the auto-delete function for communications relating to Lively. As for the other defendants, they either did not use Signal prior to December 20th or used Signal only for communications unrelated to Lively. Plaintiff presents no evidence to the contrary. Third, addressed in Section 3B above, Lively fails to show that any defendant deleted relevant signal chats knowing of a duty to preserve the evidence. The allegedly deleted signal chats concern the digital campaign and the public relation crisis management strategy developed in August 2024. Plaintiff makes no effort to show that defendants had noticed a potential litigation relating to the digital campaign or public relations strategy. Finally, the use of auto-delete can be credibly explained. At the time the crisis management strategy was developed, the internet was already ablaze with stories about the Lively-Baldoni dispute, triggered primarily by Lively's conduct in excluding Baldoni from the marketing of the film and the premiere. Lively's unfollowing of Baldoni on the social media, and Lively's own missteps in marketing the film. Surely, even plaintiff would admit that keeping crisis management communications confidential and safe from hackers and aggressive media players can be credibly explained as not involving bad faith from the reason proffered by the spoliator. Plaintiff points to Barbara 2025 yet again, which hardly advances her cause. There, the plaintiff deleted documents that would have shown when the plaintiff first discovered the infringement at issue in the lawsuit. Since the deleted documents included the plaintiff's initial correspondence informing his attorneys of that discovery, the deletion plainly arose in the anticipation of litigation. The court found that even though the documents were highly relevant to the defendant's statute of limitation defense and the plaintiff acted culpably in deleting the document, the severe sanction of an adverse inference was not warranted because the defendant failed to show that the plaintiff deleted the documents to deprive defendant of the information to use at litigation as required under subsection E2. Why would she turn to a case even if it was Lyman ruling it and it didn't even go in that favor of the plaintiff? That's so bizarre because they even quote from that case where it says in that case order, today we make clear that the imposition of a sanction rule under 37E2 requires a finding of intent to deprive another party of the information used in litigation. And that's what she used, a losing case, to prove her point? That don't make no sense. They go into a bunch of other court cases as well. Other authorities cited by plaintiff is also in opposite, and they just kind of take all of the cases that she put in her motion and turn them against her. These out-of-district cases involved circumstances in which the spoliation occurred during litigation or an active investigation with the clear intent to evade discovery by destroying communications. The court found an intent to deprive the plaintiff of text messages where the defendant admitted knowledge of an obligation to preserve his text messages and still allowed text messages to be destroyed when he upgraded his phone. This is a far cry from the facts before the court where litigation had not commenced. It is unclear what relevant evidence, if any, may have been deleted and by whom, and whether any defendant anticipated litigation over a planned public relations campaign during the time signal was sent to auto-delete. Conclusion. For the foregoing reasons, defendants respectfully request that the court enter an order denying Lively's motions for Rule 37E sanctions in its entirety. Dun, dun, dun. Now there are, like I showed y'all before, like over 50 exhibits, some sealed, some unsealed. I'm going to have to take the night, go through them, but I will be back tomorrow with the other part, which is Abel versus Jones. And I guess they have the same, it's a 30-page opposition motion against that for sanctions as well. And I don't know what's going on, but that whole time I was reading that, my nose is so itchy. Like all I was doing is pausing and scratching. I don't know what's going on. I don't know, but it's a little crazy over here, okay? It's a little crazy. But now it's time. Let's go over some of your comments from the week. And I just threw my lip gloss. Okay. And I just want to say thank you so much to everyone who engages in this channel and is here. I mean, I can only keep going because of all of your support. So it truly, truly, truly does mean everything to me. Starting off, we have Breakfast with Tiff. And she writes, it's so awesome to have someone in the industry call them out. Thank you for that. It's terrifying. I think I've talked about this before, but it's real scary. Yeah, I think there's a lot of actors who have already said to me, like, I can't believe you're doing this. I can't believe that's what you talk about on your podcast. How frightening it is. But I ain't scared no more. I would rather stand in truth and call justice and end up working with people like the Wayfarer people over ever dealing with anyone on the other side. So it just is what it is. And morally, I just feel like because of what I've gone through and now I see what they're going through, I just have to use my voice and my platform. And this is the cause that I am fighting for, okay? And it's justice for Justin and justice for Wayfarer. At Kirsty Monkeys 1 says, Lily Bloom gave birth. Blake Lively was acting. She didn't actually give birth. Right. There's wording is very important. I think that's so true. Like Blake Lively was just acting like it. And the fact that she was so embarrassed and needed a close set and it was so chaotic and all of this while she was acting like she was in labor and giving birth, but then is demanding another woman's real life labor and birth. Okay, something's not right there. Aunt Lala wrote, I know Blake was there as they can be present for all of it. The comment about how you can tell Miss Lively she can write me a check was definitely meant for her to hear, and he probably made eye contact with her. And that's about the boss, the one, the only Steve Sarowitz. I mean, y'all know how I feel about eating the rich and no ethical billionaires, but I don't know. Steve Sarowitz kind of won me over and continues to do so. His deposition expert was chef's kiss, and he takes a lot of digs at Blake Lively, and I think you're totally right. I mean, he knew that she was whether she was there or not, but I mean, she definitely read it. Oh, actually, we can't even say she definitely read it because she didn't even read the book. But yeah, I loved when he said that, like, she can write me a check, I'm waiting. At Brittle78 wrote, oh my God, I love your rundown. Thank you so much. With love from Australia. Oh my gosh, we have people from Switzerland. We have people from Australia. We have people from Canada, America, everywhere. So cool. Brittles, welcome to In Frame. We are so honored to have you. And yeah, super exciting. I love it. Australia, baby. Let's go. At Mary Shamazian 3239 wrote, at this rate, we'll see the Epstein file. At this rate, we'll see the Epstein files unsealed before Blake. Oh my God. This obviously made me laugh so much when I saw it. I think it was yesterday or last night, and it still does. I think it is so good. I wish more people would be saying this and like commenting this on everything, because at this rate, you're so true. It's so true. Like we're going to see all of the Epstein files before we ever see anything unsealed from Blake. I mean, they're going to fight tooth and nail to keep every one of her communications sealed. That is 100% facts. At OSV369 commented, well, at least now she's agreeing with the truth. There was nothing wrong on set. Yes, and this is from Miss Colleen Hoover, when in her interview with Elle, she said, I was only on set like for a couple of days doing a cameo and there was nothing wrong. Thank you. Thank you, Colleen. That's actually one good thing and the only great thing that you've said throughout this entire thing. And you're absolutely right. And thank you so much for pointing that out. At Miss Jack 1204 wrote, let's make sure Wayfarer grants an extension for Turkey Day when Lively refused an extension when Freeman's house burned down. Lying Lively has a lot of nerve. And I had totally even forgot about that when I was doing my analysis because so much stuff has happened. Can you believe it's almost going to be a year now? Oh my gosh. But yeah, you're absolutely true. The fact that she's now asking for an extension because the 1 week isn't good enough because, it's Thanksgiving. But yet she wouldn't give them a friggin' extension when their houses were on fire and even serve them while one of the defendants was packing up their kids in a car with all of their belongings. Absolutely ludicrous. At Quarter Fate 1 says, I feel like this is Wayfarer's chess move. They knew the public would be outraged at Blake Lively for compelling the birthing video, while Wayfarer is probably thinking, okay, they can have it, but not without looking like the monster that she is. I refuse to think Freeman overlooked the objection. It's brilliant strategic move without having to get their hands dirty of smearing her. She's doing it all on her own, like always. They only baited and she bit. Absolutely agree with you. And also on the last part, you're beautiful inside and out. Absolutely agree with you there too, babes. Just Just kidding. Okay. But yeah, totally. I mean, you have a really good point, and I hadn't thought about that before, because obviously when you're, the lawyers, they have their own scenario planning. Okay, if this fails, we go here. Okay, they might do that. Okay, what if this, so they kind of are probably already anticipated, and you're so right. It backfired completely in Blake Lively's face. Like, it's horrible. It's horrible that she fought for that. The birthing video of another woman is crazy. At It All Comes Tumbling Down comments, first of all, love the name. They're trying to keep documents sealed to minimize damage during the Christmas holiday when the family will be away, or minimize exposure on their activities in the case until they settle. Yes, I fully agree. I think they are just trying to minimize the damage. There's so much damage that has already been done. And I think that there's probably a lot of things that are under seal that we will never be able to see. I fully agree with you. At Rose Wild 79 wrote, she is trying to keep everything sealed until after motion of summary judgment and motion judgment on the pleadings are ruled, in hopes of things being sealed forever and not outing her for her lies and no evidence. Instead of No Teeth Blake, we should call her like No Evidence Blake, but whatever. Yeah, I think both of you ladies are on the right track. I totally agree with you. I really think that she asked for that extension because she thinks the judge is probably going to rule quicker than that is done. But he even said it in his order like that it will be unsealed before he makes his judgment on it. So we'll see. But I'm thinking along the exact same track as you, definitely Roses. And last but not least, wow, I didn't even realize, but this is Roses Wild 79 too. So thank you so much. That's awesome. Two. We got a twofer here. I love me a good twofer, a good 2-for-1. I think Judge Lively just wants to see what other evidence. I think that's Judge Lyman, but I think Judge Lively, unless you're doing a play on words, because Lively's lawyer, but I think Judge Lyman just wants to see what other evidence on Ryan that Wayfarer has to know if they would most likely win an appeal and make his dismissal decision look bad. I think Judge Lively will start to help Blake keep things under seal forever to help them also. Yeah, it seems like he is. Oh my gosh, my nose is so itchy. I don't know I've been scratching it for like an hour and a half. Okay. I think that is what the door has been opened. I think he's opening a door for them to have a more fulsome explanation, and they are going to come hard. And I think he just wants to know, like, dang, did I make a mistake? Like, did I rule improperly? Did I jump the gun? Should I have waited, et cetera, because the public definitely thinks that, or at least the majority. And yeah, I can't wait to see I cannot wait for them to come hard at Ryan Reynolds. I'm so sorry. I can't wait because he is the one. He, I think, started all of this, the way he berated Justin in pre-production, the entire filming, everything he did in post-production. Lively didn't just wake up and think she had all of that power all on her own. Did she? No. It came from her husband and all of their little friends. And I can't wait till it's all called out. 100%. Okay, that's it. That's it for today. It's Friday. I'm going to go deal with, I don't know what's going on. But my nose has been very itchy for a long time. I feel like you guys are probably thinking like, oh my God, what's going on? What is she doing up there? It's not what you think, okay? It's just some itchies. I'm going to be live tomorrow, Saturday. I'm going to do a 2-hour live. I'm thinking at 2 p.m. So from 2 till 4 Eastern time, I will be live. So come over, say hi, stop by. I'll probably be going over the second motion that was filed today and then anything else that we missed. But I will be bringing you any of the exhibits for sure in a separate video if there's anything like real juicy that we haven't seen before. But drop your comments. Let me know. Do you think the judge is going to grant Lively's motion for sanctions and spoliation or deny them based off the Wayfarer's response? Who knows? Of course, we're still waiting for responses from Lively now on a bunch of stuff, and it is Friday night. So y'all already know that Friday night dump is coming in the court docket, okay? I will keep you updated all weekend. Don't worry. I have no plans. I'm not going nowhere, okay? I hope you're all having a good day, and you're able to relax this weekend, maybe spend it with some loved ones or alone and just return back to home and find some peace and some happiness and love yourselves a little bit more, because when your cup isn't full, you're no good to nobody else. I love you, and I will talk to you soon. Bye.